Lisa's a killer. Lisa. How good is she, right? But this is an incredible group, and we just appreciate it. Again, if we win here, you know, Chelsea, we do all these things, and who knows, right? But you win here. The automakers and the auto workers, you can forget the auto industry if we don't win. We're going to bring tremendous amounts of plants in. We're going to bring them in because we're going to do it with tariffs. It's so simple. They're building now two of the largest plants in the world in Mexico, and China owns them. And they think they're going to make cars, and they're going to sell them into the United States, and there's not going to be a price to pay. We're not going to let them do it. They're going to take all our jobs. These plants are massive. A couple of them could take half of Detroit. You know, it's the real deal. A friend of mine builds plants. I said, I want to go see a plant. I want to see what it's like. Oh, good. We'll go to Mexico. I said, no, I want to see one here. He said, the big ones are being built in Mexico. And they're owned by China to a large extent. The two that I'm talking about are, oh, can you believe it? This would never happen. 4 years ago, they were not doing it because I said, if you build a plant, you got 150% tariff that we're putting, and you're not going to be able to sell your car. You can sell it, but you're not selling it in here. And they will destroy our auto industry totally. And we're going to make it, we're going to double it up. I'll bet you we will double it up within the 2.5-year period. In 2.5 years, it'll be doubled up. So I just want to, you ought to spread the word to this character that the head of the union, he is selling them down the tubes. I just saw a poll, we have 88% of the auto workers, and he endorsed Sleepy Joe. Crooked Joe, Sleepy Joe, I guess it doesn't matter anymore. Somebody said, oh, you shouldn't waste your time. He's the president, right? He's the president. They said, oh, don't waste your time with him. He doesn't matter. Can you believe it? So we're going to have a great time. When you look at their convention, when you look at what they were really saying, and what they weren't saying is worse. They didn't say what they're going to be doing. I will tell you, we're going to make America greater than ever before. I appreciate your support. That woman with those beautiful eyes, and she's crying. She's crying because she said, sir, you won it the last time. And we did. He won it the last time, too, by the way. I'll be honest. He's less controversial than me. He may not want it, but he won it the last time. But he's doing great anyway. John is doing great. Thank you all very much. We appreciate it. Enjoy the pizza. Okay? Thank you, sweetheart. Thank you. Thank you. We'll come back. We'll be back. We'll be back a lot. Thank you very much. You want? Come on. You want a pizza? Come on. He's a good man, you know? He is a good man. Come on, take a picture. I guess so. Come on up. Do you want to get up there? I want to take pictures. Thank you for coming to Michigan.
Chelsea, your viewers over
Keep coming to Michigan.
President Trump's a hero.
He is our hero. Thank you, guys. Thank you. I like that. Thank you, buddy. Come on in. Come on in. Anybody, if you want to come in. This is important. Important.
I got Get over here. Right here.
Sorry, which one is that? Is that the new one?
This is the one I got.
We have a new one.
Of course.
Thank you for honoring our fallen heroes. Thank you. Back up a little bit later. Back up a little bit later. Back up. Let's take a good picture.
Right here. Sandra, this is going to make your day long. I'm going to cry. I'm really. Are you girlfriend? I'm seeing people that are going from Democrat to Republican. Like I've never seen before.
But she's here in spirit. She's here in spirit.
That's what happened.
Thank you.
Lisa, could I get one of you?
Come on in.
I'll take it right here.
He's got 100. This is Eric. Yeah, he's great.
So he's doing okay, right? I think he's great. You know, he's
Just keep taking pictures, Tommy. We'll send it to everybody.
I don't know whose phone I got.
It's fine. Just keep taking pictures.
you let him know that. Can I get one with you? And the president? I think you did the right thing.
Okay, so let's do one right here.
Come on in. Come on in. Can you tell us? Come on. Look at the arms of this. Look at these arms, fellas. Come on. What's wrong with you?
Right here, right here.
Come on. You too, how are you doing? Life is good.
Great.
All right.
You got my phone.
All right, right here. What about this Wayne County people?
Last one right here.
How are you?
She was working.
She's working now? She's old enough to work?
No,
She's
no,
not
no.
800 doors. 800 doors.
And the response is Can the response is really good?
It is. Almost everyone is saying they're voting for you, and I'm so excited about it.
And I'll be back.
Okay, thank you. Sorry about that. All right.
I'll make sure. Yep, I got it. I want to do it. I'll do that 100%. Okay? 100%, I guarantee. Let's get this sucker over with. You'll come too, and we'll celebrate together.
I'm more worried about her.
Ready? When we win, this whole group is coming to Mar-a-Lago. Forget your daughter, the whole group is coming. We're going to win it. If we win this, we are.
Yes.
We don't win it, I'll take that.
We're winning. We are
The
winning.
whole group. Okay?
What are your plans to counter the post-DNC fundraising boost that Democrats saw after Vice President Harris's speech?
Well, I think they're doing very poorly. I'm leading in the polls. They had their, what they call their little period of time where, you know, typically somebody goes up. They didn't go up at all. We went up. So could you move, please? Secret Service, yeah. No, I think we're doing phenomenally. We're leading in the polls. We're leading here. What do you think, Ken? Yes?
Absolutely. It's because of these volunteers.
So we just came in to say hello. We want to pay our respects, and I think we're going to have a great election. And are you seeing it even better than last time, right?
Yes.
Yes. Way better. Too big to rig.
I think we're going to do a great job. Who are you with?
NBC, but the pool.
NBC. NBC fake news.
Fake news.
Yeah, tell me, have you done a story on Afghanistan today? Have you done that story, NBC? You know, the press never talks about Afghanistan, the most embarrassing moment in history. No, but have you done the story? Today is the 3rd anniversary of Afghanistan. Do you know that?
Yep. One more question.
No.
Fake news.
That's the she doesn't want to take that. Okay, ready? Today is the 3rd anniversary. I just left Arlington National Cemetery. Do you know that?
Yep.
We buried people. We honored people in Arlington, and the press doesn't even cover it because they're fake news, and they should be ashamed of themselves. That's the question you should be asking, not little trivia. I just want to thank you, everybody, very much. Don't worry. Don't worry. You'll never see that. You'll never see that on television.
Thank you, Mr. President.
I have it. I have it.
Trump, thank you for being so brave.
We love you. We love you. Thank you.
Macomb County won't let you down.
Here's your purse.
All of you.
Can you pass that back to Lisa McLean, please?
Here, Lisa. Got it? Got it?
Okay. Thank you. Bye, everybody.
Do you want Congress to
Bye, everybody. Thank you very
Bye,
much.
Mr. President. We'll see you next time you're in town.
I got you.
Are they going to do any, like,
I'm sorry. I'm sorry. I'm sorry.
Okay. Drop me out here.
audio is down. There you go, Jillian, you little badass. That's a good one. Yeah. Hashtag you kick some ass. You there, Mr. Steve?
in Hawaii, because the vote was so close, it was uncertain what would happen. In Arizona in 2020, there was allegations, and as Luis claimed in the indictment, false allegations about voter fraud, but nothing to the level of what Hawaii had, where it was unclear what would the final result and tally would be. Also, Hawaii's determination would not have made a difference. It was one state that wouldn't have made a difference in the final determination of who would be president. Here, we had 6 states, Arizona one of them, that would have made a difference in the end.
But at the time that the electors signed this certification, it wasn't known then whether it was going to or not going to impact the election, if this was the only state, for instance. I mean, the fact that it turned out that even if they broke the law in Hawaii, it didn't matter because Kennedy would have won anyway. Okay, so how does that come into play here to say, like, no harm, no foul?
It goes into the whole scheme and the attempt to overturn the election results, because this was a concerted effort, especially with the national figures, to overturn the election of the United States. And so by working with the other states to try and do the same thing, have Republican electors meet in other states as well, it just goes to their mental state of intending to overturn the election.
What actions on the part of Mr. Lehman were part of that concerted effort in other states?
He wanted Vice President Pence to accept the Republican electors.
And that's by joining in the government lawsuit.
Yes, and also being aware of Hoffman, who had sought Vice President Pence to accept those the Republican elector votes. And again, for 16.4 purposes, all of this would be factual information that would be for the jury to determine. Finally, Lehman's prosecution is not preempted by federal law. Federal law provides the states the opportunity to determine how electors are able to vote. Under Kansas v. Garcia, which is 589 U.S. 191, 2020, a U.S. Supreme Court case, laws of general applicability can't be preempted, and that in that case it involved illegal immigration case, and Kansas was able to charge ID theft. So certainly in that case where it involved immigration, which could be possibly preempted by federal law, and that being acceptable. In this case, fraudulent activity has been defined by Arizona Supreme Court as must be broad enough to cover all of the varieties made possible by the boundless human ingenuity, and that's in State v. Haas, H-A-A-S. There is no due process violation. The forgery, fraud schemes, and conspiracy revolve around conduct which was intended to overturn the election. Defendant Lehman signed a document claiming that he was the duly elected elector when he was not, and that was done with the intent to defraud, which the grand jury found based on the entire presentation. Any arguments that he did not have that intent or that the state is unable to prove his case is better suited for trial. Defendant Lehman, Eastman, and Giuliani and Roman have provided no information to support a dismissal under Rule 16.4. The indictment is legally sufficient. The grand jury did not believe the defendant's defense, but they still have the opportunity to provide that defense at the time of trial. But it is not a basis for dismissing under Rule 16.4. We would ask that you deny their motion.
Thank you.
I'm going to ask. Hey, Judge, do you mind if I address your hypothetical? I think about Hawaii.
I'm fine with hearing from anybody that wants to join in this conversation. I know that there's a rule about one attorney, but...
Well, I think we've heard from numerous ones from the defense side.
But not representing the same party.
Get it.
Yeah, we gotta check.
Okay, and I'll note the objection for the record, but I would like to hear from you on that one issue.
Yeah, Judge, you had raised a hypothetical, so let me rephrase it. Nick Klingerman, for the record. And basically it says, well, there were pending lawsuits. What was Mr. Lehman supposed to do in terms of withdrawing his vote? And if I was his attorney, I would have told him, don't withdraw your vote with pending lawsuits. Absolutely. Under the ECA and what the grand jury heard and what the state has discussed was the state has to certify a winner. That's under the ECA 3 USC 6. That was done by Governor Ducey on November 30th. Said Biden-Harris won the election. That was at the top of that proclamation, says certificate of ascertainment for presidential electors. That determined who can actually vote on December 14th of 2020. That were the Biden-Harris electors. So that was your official determination. That was the vote that Congress had to count on January 6th, barring something changing. So yes, the state presented to the grand jury, and what you heard from Mr. Lehman's attorney was that it all depends on intent to defraud. So was there an intent to defraud for the Republican electors voting on December 14th, 2020, or were they simply submitting contingency votes saying, hey, we sued under Ward v. Jackson. There's some other lawsuits. Burke v. Ducey was the name that you forgot, that was forgotten earlier, but there was a few pending ones. And if one of those changes the outcome of the election, we have to vote on December 14th, 2020 under the ECA to make sure they're counted. That's essentially what Professor Lessig says. And the state presented that to the grand jury and didn't disagree with that. That's the ECA. That's what happened. And so then leading up to that, I'd say, pending those lawsuits, should you withdraw your vote? Like, formally withdraw. This is invalid. And my response to Mr. Lehman would have been, no, don't. But you should make it clear that the Congress should not be using your contingent vote on January 6, 2021 to change the outcome of an election, barring that contingency, because that means the contingency isn't real at all. It was never a contingency. It was your plan to submit a vote claiming you are the certified elector elected for the state of Arizona to do one of two things: allow Congress to make Trump remain in office, or two, to kick it back to the states, which in Arizona were Republican controlled and would have, by all accounts, had voted for the Republican presidential electors, assuming that was even valid under Arizona law, which both Rusty Bowers and Karen Fann said was not. So it's a matter of intent, which is a jury question, ultimately. So I would have said don't, but you should make it clear your vote shouldn't be used. In terms of Mr. Lehman, his statement was, I believed it was contingent. And I believed it was contingent based on Kelly Ward's own advice. Well, the grand jury also heard evidence about Kelly Ward and her Twitter post and the other statements that she made and the emails that she sent the other electors as part of their lawsuits. And so the day after they vote, she claims that the Republican electors were the electors for the legal voters of Arizona, and then worked for the next month to have them accepted in Congress. So we're not talking about should he have withdrawn his vote. Is there evidence that his vote wasn't contingent? And the grand jury heard evidence that, so Kelly Ward claiming that they were the illegal electors, which Jim Lehman apparently got his information from, and the grand jury could decide, I'm going to accept some of his statement, all of his statement, none of his statement. And they asked that specifically. Do we have to believe him when he says it was a contingent vote? And my answer was, you get to determine the facts of this case. And that was on April 8th in the April 8th transcript. And so the point there is, in terms of the hypothetical you gave, I would say don't formally withdraw your vote, preserve it, but also don't allow your vote to be used, that's contingency, without that contingency ever happening. So it's not just Kelly Ward's contemporaneous statement, it's other electors too, like Anthony Kern. The day after he voted, he gave a media interview to the Epic Times and said, we're sending in both ballots and let Pence decide which one to accept. That does not sound like a contingency. That sounds like a plan to cause turmoil and to change the outcome of the election. Now, can I prove directly all the conversations that Jim Lehman had with all the electors and what part that he knew? No, that's circumstantial evidence. What we have pending right now are his emails, presumably, I don't know, because we have held review of those for an attorney-client privilege review. Those are with Judge Kramer. I believe he has actually talked with you about that. So in terms of, could there be more evidence of his involvement? Absolutely. But I go back to counsel's earlier statement, is that whether or not he had the requisite mens rea when he submitted ballots claiming to be the certified electors, and those ballots were actually presented and used on January 6th by members of the conspiracy that he joined by filing those under the indictment, then the question is that as a matter of law, he could admit to that and commit no crime? And the answer is absolutely not. And if you need more evidence or to hear from other statements contemporaneous, so since the grand jury presentation, we've obtained Twitter direct messages by search warrant. On January 6th, Christina Bobb had sent a DM saying, I'm working with Rudy Giuliani, the head of the Trump legal team, to try and get Congress to accept the votes. That doesn't sound like a contingency. Senator Hoffman, Jake Hoffman, then Senator-elect, on January 5th, sends a letter to Mike Pence saying, hey, there's dueling electors' votes. I'm asking you to send this back to the state of Arizona. So everyone around Mr. Lehman seems to think that these are not contingent votes. Tyler Boyer, in his Twitter DMs, says, we need to stop talking about fraud. He acknowledges that fraud isn't even the issue. I mean, privately, not publicly. And so, again, do you have a scheme to defraud, and has he joined that conspiracy? And is there evidence from which a jury could find that he should have known or that he knew based on all his other co-conspirators? Absolutely. Summary judgment doesn't exist in a criminal case. Rule 16.4, can he admit to the indictment? And I go back using your hypothetical saying no.
Okay, thank you. Mr. Willenchuk?
Thank you. Your Honor, it's almost unbelievable to me what I've just heard here. With all due respect to counsel, what I heard is a recitation about everybody else in this case except Mr. Lehman, about what everybody else did or believed or thought except Mr. Lehman, a misstatement about what I said. I never talked about mens rea or intent. That wasn't part of my argument. My argument is about Rule 16.4 and the sufficiency of an indictment here, and whether the state has presented sufficient evidence, facts, to support their claim, as opposed to the stuff that I just heard about everybody thinking this or thinking that. I heard nothing about Mr. Lehman, and I didn't hear a reference, and if I mistook that, Mr. Klingerman, I apologize, you'll have to interrupt me, where in the transcript you saw that the jurors said that they rejected Mr. Lehman's contingency testimony, because I don't have that reference.
That's not what I heard him say.
That is what he said.
No. I think he was making, at least I heard it, he was making an inference that they heard it and they still voted in favor of an indictment.
And who cares? What does it have to do with this motion? This motion has nothing to do with that. This motion has to do with the sufficiency of the indictment itself. What the jurors believed or didn't believe, he has no more clue to than what's in that record, is my point. And I don't have that record saying that. But even if I did have it, and I don't, the fact of the matter is it's not relevant what the jurors were led to believe by a prosecutor. I mean, I was a prosecutor. You probably may have been as well in your distant past, like me. And appearing in front of grand juries, as it said, you know, if you can't get an indictment, there's something wrong with you. That isn't what this is about, what the grand jurors believe. That's not what I'm talking about. I'm talking about an indictment that deals with the following facts. And the facts are this, as I said, they're very stubborn. Mr. Lehman's sole involvement in this entire case, other than all the stuff we just heard about, that has nothing to do with him, about what was going on in Washington, about Kelly Ward and her motives, about this one and that one. No, no. The only evidence that they were ever able to this day to produce, that I've ever seen produced, is that Jim Lehman, I told you, was asked by Kelly Ward to sign this and was told that it had been vetted out by people who were apparently a lot more experienced in these matters than Mr. Lehman, or Ms. Ward for that matter, and that they had historical precedent to support it, and that it was intended to be an alternate slate. Now, that's the bottom line here. Now, what we just heard is a bunch of stuff that I don't even know where it's coming from. Look, let me be clear on this. The facts are this. Hawaii, let's start with that real quick. I'm sorry to have to do this,
Before you go back to Hawaii, can I pose
Sure.
a question for you? You're saying the crime, at least as far as the filing of the certification.
Jim Lehman didn't file anything.
The signing.
Correct.
It says, I am duly qualified and elected.
Correct.
Key term being elected.
Elector, duly qualified. And
Doesn't say elector.
I don't
Is
have
a
it in front
duly
of me.
qualified elector and duly elected.
Yeah.
I want to make that distinction. Elector and elected are not the same term. One is your title of your role.
Do you have it, Lacey, in front of you? The actual language? I'm sorry, I can't put my finger on it at this second. I thought it said duly qualified and elected elector, but we can resolve that quickly. I'm sorry, Your Honor. Your point was, I think, thanks, appreciate it. Where is it? Yeah, here it is. Thank you. We, the undersigned, being the duly elected and qualified electors for President and Vice President of the United States of America. Duly elected and qualified electors. That's what I thought.
I'm assuming the qualified part because I think, if I read the statute correctly, Ms. Ward was in the position of authority to choose or ask the electors to be electors. And nobody seems to be arguing whether there was some list that showed the qualifications to be an elector. At least nobody's challenging it that I read. It's the duly elected phrase that seems to be in dispute.
Well, let's say they were wrong, just for the sake of your discussion earlier. You pointed this out, that saying something false is not a crime. So let's say they're wrong in their terminology. Let's say, for the sake of discussion, they meant to point it.
Was in the context of Mr. Giuliani saying whatever he said, and I asked his attorney.
Well, why doesn't that apply?
Because this isn't him, Mr. Lehman, saying, I'm duly elected. This is him under oath stating I was duly elected. That's, if Mr. Giuliani said under oath.
So he's being charged with a crime of stating something under oath?
No, a false certification. I thought that was what the offense was here. Fraudulent. Am I missing something?
Well, I don't see anything under oath here, but if you know better, I'll defer to you. But all I see is, in witness whereof we, the undersigned, have hereunto the city of Phoenix on the 14th of December to subscribe our respective names.
The certification has to have some legal meaning. Otherwise, anybody can write whatever they want and submit it wherever they want. It would have no.
This is not, I don't know how many times I can say this. This is not intended as the certification. Anybody would know that the governor did not submit this as the official state certification with the Attorney General and the Secretary of State.
You keep skipping to everybody would know. I'm just asking you about the charge. Is he made a false, the charge. I'm not declaring that he did so. The charge is he made a false statement
to who?
To whoever he was certifying to when he signed that. Unless you're claiming this was just a group of people who started.
No, you know that's not what I'm claiming, Your Honor.
You are interrupting me a few times here, and I appreciate that you.
I'm sorry.
Response, but I'd like to get my thought out.
I'm sorry.
If it was false and he knew at the time that he signed it that he was not duly elected, is that not sufficient under Rule 16.4 if the state can prove that he signed something with knowledge that what he was certifying was not correct, that being I am duly elected? Isn't that enough, or
No.
is that enough to get past Rule 16.4?
No.
Okay, help me with that.
Sure, I thought I went through this at length, but I'll do it again.
But you're arguing it again as if we didn't go through it before, so I'm thinking maybe I missed something.
Okay, well, I'm not being critical. I'm just saying I have argued this, and let me be clear on it, if I wasn't. As I said to you in the original argument, if this were done in some kind of a vacuum, and that was the only allegation in the indictment, I might agree with you. I said that earlier.
You did.
And what I did say was, and I'll repeat, and I don't mean it disparagingly, but let me just repeat, that this document, even according to the indictment, according to all the evidence in front of the grand jury, according to all the disclosures in this entire case, facts, this indictment is not in a vacuum. It does not just stop and say, he made a false statement on this document, he's guilty. It goes on, again, to put this in context. And again, this is where Professor Lessig's declarations really need to be reread. And again, I don't say it, disparagingly, but they really should be, because he explains this in great detail. And what he says is the context, as I was trying to explain at the beginning of my argument, the context is critical here. You can't just hold this up and say, oh, it's a false statement, you're guilty. No, because they go further and they provide that context. And the context that they provide has to do with the law and what it requires, i.e. Section 5 and Section 15, which they didn't even address here because they can't, because they misstated it completely to the grand jurors and to this court in the indictment. In that context, and in the context of Jim Lehman being told without any controverting evidence. Now, what we heard, with all due respect from Mr. Klingerman, a bunch of stuff about everybody else. But we didn't hear one word about what Mr. Lehman's context was. His only context that they presented and have alleged. I don't know what the grand jurors were thinking, but I do know what they presented. And what they presented in the indictment that resulted from that grand jury is in context that Jim Lehman, right in there, believed and was told without question that this was an alternative slate to be presented only in the event that the litigation was successful by January 6th, which it wasn't, and that the recount had occurred by then to declare Trump the winner. Those two factors. Now, we know that Ward v. Jackson sat in the Supreme Court and was not ruled on by January 6th. So getting back to the point that we were just talking to them about before I got up here, there is no need to withdraw anything for sure. Mr. Klingerman got that right. I commend him for that. There's no reason, there'd be no point to it. What was there to withdraw? The certification that had been there since November 30th was in fact under Section 15 declared to be the proper certification because by January 6th, there was no challenge that has succeeded. There's no need to withdraw something when on its face, and the statute doesn't require any such withdrawal. But what is Mr. Klingerman arguing here? Let me get that straight. He's arguing that he would have told his client, no, you don't need to withdraw it, but he argued something else instead. And frankly, I don't even understand what he's arguing because there's nothing to be done on January 6th other than the official slate, which happened, be declared to be the official slate. Now, that official slate on November 3rd stated on its face, stated by Governor Ducey, that it is subject to the legal challenges, including Ward versus Jackson, that were still pending. It wasn't a final certification. I don't know how they get away with this stuff. It wasn't a final certification. It was a contingent certification. It's specifically pursuant to Section 5 and 15 of the Federal Act, specifically pointed out that this certification is not to be final until the Ward v. Jackson case is resolved, et cetera. It's right on its face. It wasn't just, this is the official slate. It provided that contingency. It is that context that Mr. Lehman signed this document, not to be handed off to Congress. This is total nonsense. Not to be handed off to Congress and say, this is the official certification and we're challenging the one that Governor Ducey sent. I don't know where they get this stuff from. I really don't, and it's galling.
You don't know where they get it, period, or you don't know where they get it as to Mr. Lehman? Because there's certainly a lot of information about others.
Well, I'm not here for speaking for others right now.
When you say you know where they get this, you're referring just to Mr. Lehman?
Yes.
Okay.
there's not one scintilla of evidence, even an inference of evidence to go to a jury to say that Mr. Lehman in any way intended for this slate to compete when he signed it with the official certification. Just the opposite. The official certification on its face shows it's contingent. And what Professor Lessig is saying, as you were pointing out, I think, and I commend you for that, is that, listen, this had to be done by a certain drop-dead date. If it wasn't, they're gone. There is no alternative slate to be considered if if the lawsuit succeeds and the recount occurs. Now, you ask counsel, Ms. Wood, about that, and I didn't hear an answer, really. She couldn't answer it because there is no good answer that the state has, because they know exactly what the law provides. And it's exactly what Professor Lessig has told you in plain English, which is that this is not in a vacuum. This is considered, as it was historically, and I'll get back to that real quick, as it was historically, this is an alternative slate. Everybody knows it that's receiving it. It's not intended to be, let's throw out what Ducey sent and just take this. There's no statement of Mr. Lehman ever saying anything like that. It's ridiculous. This was clearly understood by him and submitted by others for the purpose solely of being in place in the event that by the January 6th date, the lawsuit had succeeded, a recount had occurred, and then another certification such as this could be considered. Otherwise, as the professor says, if this had not been signed or he withdrew from it, it would not be worth the paper it's written on. Now, I want to, if I can, because I want to be quick about this, but I want to go back to the Hawaii and a couple of other points that were maligned here. First of all, as to Hawaii, let me run through this with you very quickly. The early voting showed Nixon in the lead over Kennedy. Kennedy's campaign chairman, Herman Lum, sued the Republican electors. Lum subsequently served as U.S. Attorney and Chief Justice of the Hawaii Supreme Court, by the way. Very distinguished gentleman. He sued, and the trial court ordered a recount. Ordered a recount. It was not automatic, as you heard from the state. It was ordered as a recount. It was not automatic. The court proceedings were ongoing, just as was the case here, when the elector day arrived, which was December 14th. The Republican electors met on that day and cast their votes for Nixon. And the Hawaii governor's certificate of ascertainment was attached to those Republican vote certificates for Nixon, which ultimately turned out to be wrong. But there was a certification, just as here, that said that. I am sure, although I don't have it on me, I think I have it somewhere in my papers and I can provide it as a supplement, but I am sure that there was some indication that there was an ongoing dispute, just as Ducey, Governor Ducey, said there were 3 lawsuits pending, including Ward v. Jackson, which was at that time a cert for petition. The Democratic electors met on Electors' Day in Hawaii and cast their votes for Kennedy, just like here. The Kennedy vote certificate read, "We, the undersigned electors of President and Vice President of the United States, being electors duly and legally appointed and qualified." Very similar to what we have here. There was nothing on that document that said it was contingent on anything because it didn't need to be, just like it didn't need to be here. It was operating under the same law at the time as we're operating under in 2020, the ECA of 1878. The very next day, the Kennedy electors mailed their vote certificates to DC, mailed their vote certificates notwithstanding the Republican official certification that had been sent. Very similar. Subsequently, and it did not say contingent, subsequently the recount concluded and the trial court judge determined on December 30th, 1960, that the Kennedy electors had actually won. So we have the exact same facts, Democrats submitting what you refer to as a certificate. We can refer to it any way we want, but it was clearly not the official certificate that the governor had just sent in for Nixon, okay? So when the recount concluded and the trial court judge determined that the Kennedy electors had actually won, which is the only fact that's different in this case, meaning that Kennedy actually did win in the end as opposed to Trump. The governor of Hawaii then submitted a certificate of final determination to the National Archivist on January 4th, before this January 6th date, attaching the trial court's ruling and notifying Congress that the court's ruling would not be appealed, which means similar to what we heard earlier when I argued, Nixon did not submit it under Section 15 to the full body of Congress to determine because there was no objection registered by anyone. That's the distinction there. On January 6th, the President Nixon opened the documents, and the rest is history, and declared Kennedy to be the victor in Hawaii. Contrary to what we heard, this has nothing to do with any other state or any other states, or whether or not, you know, there would be a victory by Kennedy in any other states, as Ms. Wood argued. Nothing to do with it at all. There's no distinction there whatsoever. The case, history has nothing to do with that. It has to do with that state, just as our facts have to do with Arizona. Nothing to do with Alabama, Georgia, Michigan, or any place else, okay? This has to do specifically with the state. That's exactly what was done there in 2022, and I won't waste your time on it, but there were changes made to the Electoral Count Act that accounted for some of these issues. If you want, I'll go into that, but there were changes that were substantially made to correct some of this stuff that had gone on in 2020, including the Safe Harbor Law, which was amended as well. So that now the certificate of ascertainment issued by the governor is conclusive under the present law unless a court orders prior to the elector's day that the certificate be replaced or superseded with another. So they changed all that to correct this issue that we're dealing with today. It's very interesting to note that. Now, so that's Hawaii. Let's quickly talk about the Gohmert lawsuit, which, again, I'm sorry to say this, but it just floors me. The Gohmert lawsuit was a declaratory relief action, which you didn't hear. It wasn't stating anything by my client about Vice President Pence taking over the election or any of that stuff. It was a declaratory relief action to determine how the system would work in this exact kind of scenario. They mischaracterized that, and you can read it yourself. But the point is that on December 27th of 2020, that lawsuit was filed by Louis Gohmert in the Eastern District of Texas, and naming all the presidential electors as plaintiffs. And what did it seek declaratory judgment about? 3 USC Section 5 and Section 15, the very sections I'm talking about, okay? That's the reality. Now, why is that important? Because you heard, and we talked about this when I first argued, that the so-called conspiracy, and I think you even pointed this out to me, is dealing with December 14th, remember? Not January 6th and so forth. And that was a discussion that we had. If the conspiracy occurs on December 14th, which is the operative date of Electors' Day, the Gohmert v. Pence complaint, which they allege in this indictment is part of this conspiracy, couldn't be part of the conspiracy because it wasn't even filed as of December 14th. It was filed on December 27th, well after all the electors had already signed and committed themselves to the, quote, certificate. It couldn't be part of a pre-existing or prior conspiracy. It was a legitimate lawsuit that was brought by Louis Gohmert about 3 USC Section 5 and 15, which I've been talking about all day. And the plaintiffs argued that Constitutional Amendment 12 gives the President of the Senate the power to open all the certificates and votes shall be counted, which means, they argue, that only the President of the Senate can decide which certificates to count, which to not count. That part is correct. Further, U.S. Constitutional Amendment 12, they argue, says that the House and not the Senate has exclusive authority to decide which candidate won if no candidate obtains a majority. The plaintiffs sought declaratory judgment that to the extent 3 U.S.C. Section 5 and 15 undermine the authority given to the President of the Senate and the House under the 12th Amendment, that they were unconstitutional. The district court judge on January 1st of 2021, before January 6th, dismissed the case because the plaintiffs lacked standing, not because of any substantive problem with the complaint itself. And the Fifth Circuit affirmed it on January 2nd, and on January 7th, the Supreme Court denied application for relief. So that's the Gohmert lawsuit that they claim is part of this conspiracy. And if a declaratory relief action is part of a conspiracy or should be sanctioned, I suggest the court read again the State versus Richard case from the Supreme Court that just came out. I argued that case, and it was a unanimous decision of the Supreme Court that basically held, reversing both the Superior Court and the Court of Appeals, that election contests, even if they are long shots, should not be criticized by the courts by sanctioning them. And that, in fact, the only challenge to the rule of law, as we've heard it here, is by well-meaning or well-intended judges who don't understand that. And you can read that at the end of the decision. So there's no challenge to the rule of law here being made by my client after the certificate had already been sent by seeking a declaration through Louis Gohmert of the Eastern District of Texas to determine how this process under Section 5 and 15 should proceed in this particular situation. I believe, Your Honor, that those statutes are binding on this court. They're binding on the Attorney General. They do not allow under the Supremacy Clause the Attorney General to make following or trying to follow those statutes into a crime, and to do so would be not only unprecedented, but completely without the rule of law, and by the way, would be not only unprecedented, as I say, but there would be no notice, as was stated here, to anyone that doing the act that those statutes allow for, even if you disagree with how they're written, is a criminal act, and nobody, including Jim Lehman particularly, by signing this with the understanding as stated by the state. So let me be clear on that before I sit down. You know, they talk about, well, this is for a jury, this is intent and all that. No, that's not what I argued. That's not what I argued at all. Not a question of intent. It's a question of the rule of law. And the rule of law is very clear on these matters. And they've misstated both the rule of law as to the safe harbor rule, which now I predicted, and they come back and say, you know, yeah, we talked about that, but that's really not very important. Of course it's not important to them now when they realize that they were wrong in how they described it to the grand jurors and even to this court in the indictment. They then misstate Section 15 and somehow try to mislead this court into believing that it's a jury trial for my client to follow the federal law as best he could without, again, a declaration from the court at that time to know exactly what else to do other than what was done. Historically, that was what was done twice, and there was no prosecution that resulted because neither act of putting your name on this document is a crime. And when it was submitted, to get back to your point, although it was not submitted by Jim personally, it was his understanding, clearly unrefuted, that it would be submitted pursuant to that law and pursuant to that historical precedent, which is certainly not a crime on the face of the indictment. So everything that he did pursuant to this indictment, under the state's own factual allegations and what they presented as to Jim, and don't get misled by talking about everybody else, because they've tried to lump a conspiracy into what Jim signed. But you know what? There's not one shred of evidence, that Jim joined a conspiracy to do an unlawful or illegal or criminal act. Not one shred of evidence. They haven't talked about it anywhere, including today. Nothing in which Jim was in any way led to believe or aware that this document would be taken on its face as a challenge to the Ducey certification, unless the legal challenge then pending, which was pending whether they like it or not, and I know they don't like it, it's an inconvenient fact for them, but it is a fact. And it is an important fact that there was a legal challenge pending, and under the law and historical precedent, that challenge means that they had to get this in by December 14th under the safe harbor laws, because there was no restriction in Arizona on that. And they had until December 14th, the day of Electors' Day, to do so. What Judge Warner held, and what they're arguing under the safe harbor law, is it had to be done by December 8th, and therefore there would be no reason for them to have met unless they were doing something illegal, unless they were challenging something, to get to your point, that they knew was going to be taken by the recipient as being a challenge to the current certification. That's why the safe harbor law is critical for you to understand. Because if that law existed as it was assumed by them and Judge Warner to exist, which it doesn't exist, and they're not arguing today it does, because they know it doesn't, then they would have been prohibited from meeting on December 14th. And that's why Professor Lessig makes all this point about the fact, as you know, that in order to preserve that vote, this document as written had to be signed. Now, could it have said that is contingent upon blah, 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 everything I've said? Of course it could have, yes, we understand that. Just as in Hawaii, it could have as well. But that didn't make a difference in Hawaii, as it shouldn't here, because as Professor Lessig says, everybody in the Hawaii situation understood under the federal law that this would be worthless as an existing challenge.
I have a question about Hawaii.
Yeah.
It's being cited as if it's precedent. It's just an historic event.
That's right.
And that historic event may have led to prosecution if, after the Kennedy electors sent in their certification, it turned out that President Nixon had in fact won Hawaii, there may have been prosecution. But the fact that what the governor had first certified, that being that President Nixon won, they weren't going to prosecute the Republicans when it later came out as a recount that it was Kennedy who had more votes.
The Kennedy electors are the ones who sent in the uncertified.
But it turned out that they were correct.
Yes.
So it keeps getting cited as if it's precedent here. Maybe it wasn't prosecuted because in the end it was overturned no differently than if in the end here it turned out that the arguments in favor of President Trump were.
Yeah, I understand.
So I just want to make it clear, Hawaii is very illustrative of the kinds of issues, and I appreciate that. But the fact that nobody got prosecuted there is not precedent of what should or shouldn't happen here. Would you agree?
I do agree with that, of course. I can't say that anything that happened anywhere else, including 1876, is binding on anything. You're absolutely correct. But what I can say is that the historical precedent of nobody being prosecuted until this recent last election in 2020 is significant. And I'm not going to get into the politics of it all. I respect that. But what I will say is the politics certainly were present in that campaign as well, right? I mean, that was another hotly fought campaign where there was a lot of political, discussion, just as there was in 2020. But putting all that aside, Your Honor, you're absolutely correct. I haven't cited it to say, look, the state cannot do this because of that. What I have said is that it's clear that people who are signing this, such as Jim Lehman in particular, were led to believe that there was a precedent that people had not been charged with anything because they were following what I'll call Section 5 and Section 15 as the law on the subject. And therefore, that's why I contend that nobody was prosecuted in Hawaii or in 1876. Because in 1876, of course, you didn't have the ECA. It was adopted because of the 1876 election. But nevertheless, nobody was prosecuted there either for their activities. And I believe that that is an important point to consider. I would agree that it's not binding on anybody, if that was the question.
I have a question that's off of this subject. Are you finished with this?
Yeah, there's other points, but please, I'm happy.
You in your reply, and I'm going to indicate which part I'm quoting from, wrote on behalf of your client that he was, quote, duly elected because he was appointed to serve as an elector. Is that what you're arguing, that being appointed to serve as an elector is the functional equivalent of being duly elected?
I believe that was one of the points.
That's the only one I'm asking about at the moment.
Oh, okay, yeah, I just want to be clear that that's not our only point.
No.
Yeah, but yes, to answer your question, as I said in my original argument, let me repeat, because sometimes that's important. What we argued was that, I believe that, if I recall correctly, that Section 5131 was analogous in that it also discussed these same kind of terms. And in my recollection, it was synonymous essentially to appointment, elected or selected, if I recall correctly. And that because of that, there was no great importance to this duly elected statement, as if it's the end all and be all and makes these people criminals because of the language duly elected and qualified electors. They would be duly qualified. Well, qualified certainly is a term of, opinion, so I don't even know what that is, but let's stick with the elector. because that is more of a factual kind of statement. But again, this is to be read only on the date that the recount is done and the election called for this to be submitted to the vice president. It is not to be read in a vacuum that, oh, I'm reading this and they're lying because he's obviously not on that date duly elected. What I was arguing in the reply was you can play around with these terms, and that's why I said to you earlier, I didn't mean to be offensive, but that's why I was saying earlier, you know, whether or not calling something or saying something falsely is a crime applies, because I don't think any of these people intended this to mean anything other than either it's contingent or the only other option would be they obviously know they're not elected at that time in the sense that we've been talking about. So Jim Lehman isn't handing this to somebody as they're trying to assert, saying, oh, election's over, Trump has won, and I'm his duly elected elector. That's not what happened here at all. If it did, I would agree that might be deceptive and misleading. That's not what happened.
And you're saying it's not what happened because you're getting into the underlying facts. I'm just asking you about the meaning of words.
Oh.
A definition of the word elected would mean chosen by vote.
That's one interpretation. I can honestly say, as I just said, I think it could also mean that I've been appointed. As such, I've been elected, selected, appointed.
When I got appointed to the bench, I could have said I was elected to the bench. When we know in Arizona, Superior Court judges are appointed by the governor.
Would you be expected to be charged with a crime for saying that if you had?
If I had said, using, just because you asked, if I had said I've been elected to be a judge when in fact I had not been, that might, depending on the context of where I said it or where I submitted that, or if I showed up at work and took the bench and said, I've been duly elected.
Let's put it in terms here. If you were trying to obtain some benefit directly from doing that, I don't know what it would be. I don't know what it would be here. But
the benefit is your candidate wins. So we could.
That's not the benefit. If you're elected.
But I'm not looking to debate. I just want to understand words. And I think words have meaning. And we have legislators here or former legislators who every word that they put in legislation, I view it that they had meaning, not for me to interpret what they meant, but for me to give it its plain meaning unless you cannot ascertain it. When the term elected was used, I view that to be chosen by vote. That's plain meaning. But you're saying it could be, no, it could be appointed.
Well, let me answer it honestly. It is not a defined term anywhere that I'm aware of. We know in contracts there are defined terms. There's also defined terms in legislation. It is not a defined term so as to put anybody on notice, if that's your question, and I think it is, such as my client, that he would be criminally charged because he referred to himself duly elected and qualified elector. I don't think that anybody with a sane mind would argue seriously, except maybe the Attorney General, that this would be criminal activity if it's not defined anywhere. So that's my best honest answer to you, is that if it's not defined, then when you ask me what does it mean, and I ask you what does it mean, we all have opinions on what it means. But that doesn't mean that that's a criminal act unless it's fair notice and clear notice to somebody who's being charged with a crime. And that's why we're here, because it is not. And to say that is no different than saying what you said earlier, which is that some bright person here said that, you know, saying something falsely is not necessarily a crime. It could be under certain circumstances, right? But generally, if I, as I said, declare myself president, who cares? I'm not committing a crime unless there's some point to that I'm using it. And there was no point to this other than what Section 5 allows for. Let me just end this by saying a couple of quick things, if I may. I know we've gone on, but I have to say this because I have a duty to say it. I have a duty because I realized during the lunch break that I had misstated something to the court, and I believe under ER 3.3, I didn't have a chance to look it up, but that's just my recollection. Could be wrong, but I have a duty to the court to correct myself when I realize that, okay? It's actually better than I thought, but it was still a mistake. The statements that I was reading to the court out of my notes did not reflect who the question and answers were from. I assumed when reading it that it was from the grand juror, and you asked me a specific question about the use of the term that they were talking about esoteric, thank you, an esoteric litigation, which I refer to as not esoteric at all. It's very clear. They just got it wrong. Actually, my mistake is it was the Attorney General's office that was the one that was using that term. And specifically, the way I saw it here as we looked at it, Nick Klingerman was using that term on at least 2 or 3 occasions in those pages, and not the grand juror. And also some of these answers questions that I referred to with Mr. Ignowski, who was their investigator, was from Ms. Wood as well. It was not from the grand jurors from what I could see. And I'm sorry for that. I took it very quickly from my notes. And I believe it's actually better because it was the Attorney General's office. If you go back and look through those pages, 1 through 100 will basically page 60, 67, I think, in that area. But you'll see that it was actually the Attorney General's office using those terms. So to come back to that argument very briefly, when they're talking about esoteric litigation and answering all these questions, and we went back and forth, I'm not going to repeat them all, with some of the people involved in this case, have certain motives versus other people. I think it's now highlighted even further that they did understand that the law was important. They simply minimized it to the jury by calling it esoteric. It wasn't the juror.
Wouldn't that be more appropriate for a 12.9 motion than it is about this motion here?
It could be, Your Honor, but I don't want to, again, say anything misleading. I could be, but I do believe it is relevant here, very much so. Because as I said, at the end of the day, after all is said and done, here's what you're left with. An indictment that says that Jim Lehman believed that this was contingent, acted upon it, said it to everybody, and was told that. And that he joined the Gomert lawsuit after, it turns out, this alleged conspiracy had already been concluded, essentially, on December 14th, to get a declaration from the court. That's it as to Jim Lehman. There is no more. There is no more. That's it. And all this other stuff you've heard is just gilding the lily about other people, Kelly Ward's view of things, somebody else's view of things, on and on, people in Washington and what they were doing. Who cares? The Attorney General understood clearly by what I read to you this morning that there was a distinction between various groups of people here. And that distinction should be in the court's mind first and foremost when fairly dealing with this motion under 16.4 to determine if that indictment can stand. And I'll say this in conclusion, that if this indictment can stand, and I do not say this lightly, it would be a very, very scary day in American history for people like this to be charged with criminal activities for doing what they're required to do and swore to do and did do under the legislation adopted by the United States of America for just this very purpose where this particular situation arises.
Thank you.
Thank you. Appreciate it.
Judge, could I just briefly address the legal issue? It would be a second. Well, it's on the standard for forgery, and you had asked a question about is simply misstating something, and we're going to address it during I think the anti-slap, but my only point was
I will give Mr. Wilenchek the last word, but go ahead if you.
Judge, the only thing I was going to say is simply misstating something, even in writing, is problematic under the First Amendment. The legal standard here for forgery is intent to defraud coupled with a false statement. And so when we're talking about that, I just want to be clear as you're looking at whether you're looking at that being certified or not. It is the combination of intent to defraud with a false statement. That was it.
Okay. And I've been assuming that all the way through here, that the duly elected is what you're alleging to be the false statement, and the inferred intent was to have that false statement relied upon or used in some fashion other than authorized by law.
Correct, Your Honor.
Okay, that's the underlying charge as I see it.
Well, and let me respond to that quickly, which is very easy. He's making this into an intent to defraud, but the last part of what you said is what's critical, because under my motion, under 16.4, that last part is the key, which is whether or not it's authorized by law. It doesn't matter whether they had an intent to do anything. What matters is that their actions are authorized by law. That's why I stayed away from the intent in the mens rea. I don't think that's relevant here. They want to make it relevant to make it sort of a factual issue. I'm saying to you, the last part of that sentence that he just said cannot be shown here whatsoever because they misstated Section 5 and 15. All you need to do is read it to see that and see their statements about it and whether they misrepresented them.
Thank you, everybody. We are going to close the chapter on this motion, and we're going to reconvene in about 10 minutes to deal with the, could we all agree I could call it anti-SLAPP and we'll all know what I'm talking about with no?
It's anti-SLAPP, yes, Your Honor.
Okay. So we will do that. Let's about around 3:05. I want to give the court reporter a break here. So I'll see everybody back here in about 10, 12 minutes or so. Thank you.
Oh, boy.
Oh, and by the way, on another note, we're going to stop at 4:30 or as close to 4:30 as we can. It's a long day for everybody. And we'll reconvene tomorrow at 10:30 back here but I want to make sure that there's an opportunity to hear from those who are not going to be here in person tomorrow. I know that includes you. So if you could during the break discuss that so there's ample time to have those individuals heard.
Mark Williams for Mr. Giuliani. Does my client have permission to be excused from tomorrow?
Everybody who wants to be excused as far as the defendants in person or virtually, I'm leaving it to you of whether you're waiving their appearances.
Okay, thanks.
All right, thank you.
Thank you, Your Honor. Sorry, I went to the table.
No, we're glad to have you here. We're honored.
I was going to say, I thought I was sitting with somebody else.
We're honored to have you with us.
Oh, thank you.
Because Michael, welcome back.
Sorry.
Make sure we get it. No, I'm trying. Let's see how far we get.
I'm sorry. Yes.
We could finish it. Somebody might pop on work.
We're done.
There might be somebody else chime in and wants to own the state. We're not going to finish that.
What are you saying? Oh. It's general complaints.
I don't know.
Oh, yeah. Yeah, you didn't agree to that. Well, get up there and speak. Yeah, no, that'd actually be better.
Should I get some water? Yeah, I need to do that too.
Yes.
Seems to satisfy me. It's hot under there.
The pressure.
Yeah.
She lives here, and I work out with her husband.
All right.
Jim said your thing, so let's see what he said.
Got a chance.
Okay.
Yeah.
At some point I heard a water. Oh, but since it's over here, Perhaps I shouldn't touch it.
There moved it.
Okay. I won't drink it now. Right? Let's do this one.
That's what the wards were saying.
Oh, thanks.
They're not going to approve you.
I don't think so. Well, let me take back all the conversations.
Yeah, right. Yeah. I said, well, I learned that's the First Amendment right. Yeah.
I agree with you. It'll be sad.
At least 600 miles. Minimum of 30 gallons. So there and back. So it's about $300. Okay.
They did it themselves.
Oh, they did, that's right, yeah. So we deal with this. Exactly. They're not a great chance, but it's the only one. Right. Yeah, we got it. I know. Right. Oh.
Thank you. Thinks he can just speak whatever he feels like he is. Yeah. That's what I got. I just feel it. Oh, you're right. I've been around him for many years. No shame.
Let me just ask him.
Yeah. I see.
Make sure you don't need it.
Yeah, I'm full.
Thank you.
Oh.
You guys need to set really attention.
Yes.
Now you can.
I'll talk to you.
He's online.
It may be your second to last password. It's been a while.
You'll wind up working out why.
It's always good to be prepared ahead of time.
You realize you have to look at it. But he's already gone. Yeah, oh, yeah.
I just like that over there.
Thank you, everybody. You may be seated. Thank you. We are back on the record in CR 2024-006850. And Council, you may proceed.
Thank you, Judge. Andrew Markentel for Senator Kern. As I mentioned earlier, Judge, I'm going to attempt to kind of MC this oral argument with the amount of speakers that we have and the amount of topics that we want to cover. We figured that we would get together as defense counsel and try to give some sort of organization for this afternoon's argument. I'd like to give a roadmap kind of to the court of where we're going, a brief summary of what each speaker is going to talk about. And I should mention before I do so, this is not an exhaustive list likely. As I just found out from talking to other defense counsel, there might be some additional argument. They're going to wait and see if what they want to bring up is covered. So there might be some additional speakers, Judge. First, you're going to hear from Ms. Adams for Defendant Eastman. She's going to talk about the legislative history of the anti-SLAPP statute and the important constitutional rights that bear on that legislative history. Next, and I should mention too, Judge, I've ordered these kind of keeping in mind who needs to leave on a plane in a few hours, and we're trying to get all those people in. Next up, we have Mr. Colombo for Defendant Hoffman, and he's going to address the prima facie standard, why the standard has been met, and he's going to explain to the court argument related to the indictment, in this case, as retaliation and punishment for activity that is not unlawful. And finally, he will be arguing that this court should exclude any arguments outside of the very strict purview of determining what is the prima facie standard and whether that has been met, because there are some arguments that concern the defense in the Attorney General's response that we'll basically be asking the court to not consider in today's hearing. Next, Judge, you're going to hear from Brad Miller, who is the attorney for the wards. He's going to be specifically addressing certain aspects of the Attorney General's response, which, as he will argue, is basically requesting this court to create new law and add additional elements to the prima facie test. Next, Mr. Miller will discuss kind of generally, I think, in support of the motion. And finally, the last one I have listed here, Judge, is Mr. Jacobs, who is counsel for Defendant Bob. And he will specifically address with this court arguments supporting that the Attorney General's retaliatory intent with these charges and their motive for bringing these charges. And as I mentioned, Judge, I will try to kind of prompt people. So if you see me moving around, that's to try to keep everything on track. And there may be some folks that want to speak at the end.
All right.
And I don't think we take a position on whether it's an anti-SLAPP or an anti-SAP. I think it's funny that Mr. Jones was in the room just long enough to thoroughly confuse everybody about that.
He was. And then he left.
So with that, Judge, we'll have Ashley Adams for Defendant Dr. Eastman.
And Ms. Adams, before you begin, there's been a question in my mind that maybe you can answer or everybody can chime in. From what I got out of the amicus brief is there's two threshold questions. The substantially motivated one is one question, and the other is the word involved, that the conduct or involved the exercise of a constitutional right. Am I off base to see those two separate elements under this prima facie umbrella, that it was involved and substantially motivated by? Is that fair?
I think that's precisely correct, Your Honor.
Okay.
I think first it is our burden to show that the activity in question involved First Amendment rights, which I'll talk about in detail, and then also that the conduct or the action in question was substantially motivated to subside or to quash that right. So that is correct, Your Honor. There are two things that we must show as part of our prima facie case.
Thank you.
And Your Honor, I want to go back to what you said at the very beginning of this. This is a matter of significant importance, as you recognized. This issue before you strikes at the very core of our country's values, the right to express ourselves freely, the right to protest, the right to criticize our government and to complain about things that maybe we don't like or we think ought to change. The right, in fact, to say things that may not be kosher or politically correct or even popular. And I understand that what these defendants did was not very popular with some people, especially the Attorney General. But that is not the point, Your Honor. The point is that the First Amendment is the grandest and the most sacred, of course, constitutional amendment that we have. And we must do everything we can to protect that during the best of times and the worst of times. When I was preparing for my hearing today, I came across a story about a Cuban musician and songwriter who wrote a song that was critical of his government. And eventually this song became a pro-democracy anthem and became very popular. In fact, it was awarded the 2020 Latin Grammy Song of the Year. But unfortunately in 2022, this gentleman, Mr. Castillo, was arrested and he was sentenced to 8 years in prison. And I submit to Your Honor that that's what it looks like when you criticize your government without the First Amendment protection. We only have to look to Venezuela, where President Maduro is currently rounding up people, those who do not think that he should be in power for 6 more years. And so our forefathers did everything that they could to make sure that arrests like Mr. Castillo's arrest and rounding up people because they criticized an election didn't happen in this country. And so as part of our First Amendment, of course, we have the right to petition the government for redress of grievances, is what the Constitution says. And James Madison himself made clear during the debate back in 1789, and I quote, "The right of freedom of speech is secured. The liberty of press is expressly declared to be beyond the reach of this government. The people may therefore publicly address their representatives. They may privately advise them or declare their sentiments by petition to the whole body. In other words, in all these ways, they may communicate their will." And since that time, Your Honor, the Supreme Court has found that a number of things fall within the right to petition. For example, in McDonald versus State, writing a letter to the president was found to be included within the right to petition, or a letter to the vice president, as a number of these defendants have written here. Protests, of course, are included within that right. Filing a lawsuit, circling or circulating a ballot initiative, contacting a government agency, making a complaint. I was only able to find one criminal case in Arizona where the court did in fact strike the indictment based on an anti-SLAPP violation. It was in a very small court, and I have a copy of the decision I can provide to Your Honor, in the Justice Court in Verde Valley. And there, the defendant had filed a complaint against the police department for how he had been treated during a stop. And the court found that, yes, that was a lawful exercise of his right to petition. Importantly, the Supreme Court in United Mine Workers versus Pennington found that the petition clause protects a, quote, concerted effort to influence and contact public officials. So in light of all those very broad rights, Your Honor, I think it's important that we kind of go back in time to what was happening in 2020. This election took place right after COVID, or in fact, in the middle of COVID. These were not normal times. COVID did a lot to alter the election. Not only did it cancel conventions and transition campaign funds into the digital realm, many states were forced to rapidly change how people got their ballots and how those ballots were submitted. And so there was a lot of concerns. I know we all read about it in the newspaper, about drop boxes and mailboxes and mail-in ballots, lots of people talking about that. And then we fast forward to Election Day, where Arizona voters went to bed believing that President Trump had won the election, and then woke up the next day to hear that President Biden had in fact won the popular vote. And so there was a lot of confusion, a lot of talk, and a lot of concern. Now, the state's own witnesses in this case, Your Honor, have described during their interviews the chaos that followed. There was a flurry of activity, complaints about polling places, rumors about illegal immigrants voting, allegations of voter registration violations. We've all heard the term Sharpie Gate, reports of tampering, all of these things were going around. There were protests in the streets of Arizona. There were people trying to break into, the county electors' offices. So lots of things were going on. Karen Fann, the president of the Arizona Senate, told the investigators in this case that she had seen a poll that 46% of Arizona voters did not trust the results of the election. And so, as she said, something needed to be done. And at that point, the Arizona Senate commissioned an audit. I think it's important to note, Your Honor, that there's no evidence that these defendants started those rumors or manufactured these complaints. Instead, these defendants, like many Americans across the country, were concerned about what they were hearing. They were worried that there was foul play. They were worried that maybe, in fact, this election had been stolen. And I think that's what they truly believed. And so they did something about it. And what did they do? They exercised their First Amendment rights. Some filed lawsuits. Some tweeted about their concerns. Some went to the press. Some contacted their government officials, or they met with them. My client, Dr. Eastman, an attorney, engaged in all kinds of conduct that was protected by the First Amendment. And I don't want to go into a lot of detail. I just want to hit a few of the highlights in the indictment. But first of all, the state alleges that he was an attorney who encouraged the Republican voters to vote. Well, last time I checked, encouraging somebody is not a crime. And in this context, it was certainly constitutionally protected speech to encourage those voters to protect the then pending election challenges, as Mr. Wolinchek has eloquently described. The state next alleges that Dr. Eastman spread wide claims of election fraud. The indictment does not identify any specific claims that they say he spread or to whom he spread them to. But even if we assume that's true, which we assert it's not, that does not rise to the level of unlawful speech. He believed, as many people did, that there were problems, and he talked about them. Talking about election fraud, even if it wasn't true, is not unlawful. It's not defamation, it's not incitement. Dr. Eastman never targeted anybody. He never told anyone to invade the Capitol, nor to commit violence, Your Honor. The indictment also alleges that Dr. Eastman, quote, pressured the legislature to change the outcome of the election. There's no evidence of pressure, but using the state's own words, they state in the indictment that Dr. Eastman, quote, encouraged Speaker of the House Rusty Bowers to convene a special session to decertify the presidential electors. Well, encouragement, again, Your Honor, is hardly incitement, but asking a member of the legislature to look into claims of election fraud is quintessential petitioning your government official for a redress of grievance. Speaker Bowers himself testified that he had this conversation with Dr. Eastman, and Dr. Eastman ultimately deferred to Speaker Bowers and said, yes, you understand Arizona law better than I do. That was a discussion between two people, Your Honor, and Speaker Bowers was free to reject Dr. Eastman's suggestion, and he indeed did so. So, and there's other allegations as to Dr. Eastman. For example, the indictment says that he wrote 2 legal memos where he presented different options in terms of how Vice President Pence could deal with the competing slates. I mean, aside from the fact that there's no evidence that anybody saw these memos or read these memos prior to January 6th, they simply represented Dr. Eastman's brainstorming ideas and legal theories. That is not a crime, Your Honor. There's also an allegation that Dr. Eastman met with Vice President Pence at the White House to convince him to delay the election. Again, he was voicing his concerns about illegalities, about problems with the election. Again, petitioning his legislator or petitioning the Vice President to address these various grievances. In sum, Your Honor, all of these activities work in conjunction with Dr. Eastman's First Amendment rights. And these defendants all engage in similar types of conduct. They spent a great deal of time trying to convince people that there were problems, and they wanted people to look into these problems. And that is free speech, Your Honor, and that is protected by the First Amendment. Speech cannot be banned even if it expresses ideas that offends. That includes political speech, racist speech, sexist, or otherwise unseemly speech. And as much as the KKK's hateful ideas make most of us cringe, the Supreme Court in 1960 held that Charles Brandenburg's genocidal talk about Jews and blacks was constitutionally protected. The Supreme Court found that because Mr. Brandenburg did not target his comments at any particular person or didn't create a plan of action for hurting anyone at that time, that his general and vague comments were protected. The Supreme Court put a very high bar for incitement in that case, Your Honor, and the Supreme Court has followed that precedent for the past 60 years. So I would ask you, Your Honor, to carefully scrutinize this political speech, and I know you will do so regardless of your political views, as you have said, because sadly these are the worst of times, and this is why our First Amendment rights are so important. If we punish speech that offends all the time, I mean, somebody like me, a woman, I might never have been given the right to vote. Minorities may never have been given the right to vote. We still might have segregation. We still might not have gay marriage if we punished speech that offended other people. And importantly, Your Honor, we cannot allow public officials to use indictments to silence speech that they do not like, or to silence their opponents, as the Attorney General has tried to do here. And so, just briefly, Your Honor, in light of these broad First Amendment protections, I think the timing of the anti-SLAPP amendments in this case are very important. The first draft of the amendments to the anti-SLAPP bill were initially presented to the Judiciary Committee on February 15th, 2022. And among other things, the term, quote, legal action was expanded to include any criminal prosecution. And that includes all criminal prosecutions, whether by complaint or grand jury, with just a few exceptions. The statute doesn't say anything about probable cause. It doesn't say anything about grand jury prosecution by complaint. It says all criminal prosecutions. There are a few exceptions, of course, drug trafficking and some other serious felonies, but none of those are at issue here. That law was originally drafted by Corey Longhofer, who I was hoping would be here today. He is, of course, counsel for amici brief. And he told the New York Times that the 2022 law's intent was to limit politically motivated prosecutions on both sides of the aisle. And I think that is very telling, Your Honor. We would suggest that an indictment just like this one is precisely the type of criminal prosecution that the legislature intended to limit. I mean, the Attorney General made no secret about what she was going to do to these defendants during her campaign. And after she took office, she certainly did exactly what she promised she was going to do, because anyone who is in any way involved with the submission of the alternative votes have now been indicted, with the exception of the few cooperators, including Mr. Cheesebro. And so I am going to defer the discussion of what the burdens are under the statute to my other colleagues, but we would just ask Your Honor to keep in mind the very important values that are at stake here, and that the legislature was very deliberate in their adding of criminal actions to the anti-SLAPP statute.
Thank you.
Thank you.
Mr. Colombo.
Good afternoon, Your Honor. There were Just by way of background, I wanted to clean up a couple of inaccurate factual statements that have been said today that may impact my presentation instead of doing it in the middle. There was a mention at one point a little earlier this afternoon that Mr. Hoffman wrote a letter to Vice President Pence to award the election to the Republican, to President Trump. But that's not what his letter said. In the indictment at page 18, you can see for yourself, the indictment spells out that his letter actually asked for Vice President Pence to delay and send the issue back to the Arizona legislature for them to decide who the proper electors were. Just a clarification there. Also, there was some talk about the comparison of the Hawaii example to what happened in Arizona and the dates of certifications. In support of our motion, we submitted a declaration of my colleague Tim Lasota. Exhibit A to that declaration are actually the certificates in Arizona, and there are actually two. There was one on November 30th, but there was also one on January 5th. And the one on January 5th is titled the Certificate of Final Determination of Presidential Electors, and the certificate itself actually discusses the litigation that had been pending in the interim. So the court may draw what inferences that it will, but in our view, that suggests that there was at least something preliminary about the November 30th certification, or that it was subject to change. And in fact, the governor felt the need on January 5th to explain that there had been intervening litigation. That litigation was now resolved, and so therefore they could make their final determination. All right, so with those clarifications, this was a close election. As the indictment says at page 23, the differences in the vote came down to 1/3 of 1%. And that may explain a lot of the agitation and confusion and disagreement that you've just heard from Mr. Eastman's counsel. Our lengthy anti-SLAPP motion in reply to the state's responses address a number of issues, but I'd first like to just emphasize that today we're at the stage in the anti-SLAPP statutes process where there's only, as to this motion, there's only one issue before the court, and that's have we, the defendants, in our motions, established by prima facie proof that the indictment was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of constitutional rights. So that begs the question, what is a prima facie showing?
What about the word involved? I didn't hear that in there, and I know that's in the statute.
Yes, you're right. You're right. And that's what, I left it out because that's what Ashley spoke to, but I'm just driving at what prima facie burden of proof means in this context. And so for us, in terms of the anti-SLAPP process, we discussed this at pages 11 to 12 of our motion in note 20 and pages 3 to 8 of our reply. And Mr. Eastman's motion also does an excellent job of explaining the standard at pages 4 to 7. As Judge Sinclair of this court held last year in the Greenberg versus Ray matter that we cite, and Mr. Eastman cites, a movement meets their prima facie burden by showing a reasonable inference that the lawsuit was substantially motivated by a desire to deter, retaliate against, or prevent the exercise of their constitutional rights or involving their constitutional rights. In our reply in Mr. Eastman's motion are listed additional authorities explaining that prima facie showing is simply a sufficient showing warranting further exploration. That is a rebuttal. Assessing our motion at this stage does not yet involve considering the state's rebuttal to come or any inference the state asks the court to draw from the evidence. That's what Your Honor would do after finding that we've met our prima facie burden and then soliciting a response from the state. In sum, the prima facie standard is whether the motions standing alone warrant a response from the state to attempt a rebuttal. This is not yet the point where the court determines the merits of the motion. It merely is whether the burden must now shift to the state to respond. If the court finds that our motions made our showing, then the state gets an opportunity to avoid dismissal of the indictment by showing, first, that the indictment is justified by clearly established law, and second, that it did not act to deter, prevent, retaliate against the defendant's exercise of their constitutional rights. The state's current response that is docketed with the court, to the extent it strays past merely discussing the prima facie standard and what it means, and actually argues the standard was not met using the evidence in the record, is premature and beyond the scope of the statute and what they're supposed to do. In this regard, a distinction should be drawn between, on the one hand, their views on the meaning of what prima facie means, and on the other hand, what could be the state's defenses in the merits in response to that prima facie finding. For example, the statute at 12-751B1 contemplates that a response argument would discuss the person who conducted the investigation, what they knew or considered, or the past practice of the relevant state actor. So at pages 14 to 20 of the Attorney General's response, which comprises a lengthy defense of the actions of the grand jury, that's exactly the kind of defense one would expect in a response after the court found that there'd been a prima facie showing. Defenses appropriate for their response after a prima facie showing would also include their explanations for what we allege were unprofessional and inflammatory statements of the Attorney General and her deputy that showed the indictment was retaliatory. In fact, despite titling their response on its cover as, quote, addressing the prima facie proof standard, pages 2 to 4 and 20 to 35 of the response are a factual and evidentiary rebuttal argument to the defendant's motions.
Those pages again, 2 to 4 and what?
2 to 4 and 20 to 35. Rather than discussing the prima facie standard itself, the court should not consider those arguments without first finding that the defendants made a prima facie showing that warranted that response. This is something which perhaps distinguishes this from the Rule 16.4 motion that we were just discussing earlier today in terms of its procedural posture and the burdens of proof. Thus, at least 25 pages of the state's response are devoted to arguing against the motion on the merits, which is, in our view, practically a concession that these arguments are needed to rebut our motion because we have made a prima facie showing. That the court should adopt additional requirements that the legislature did not include in the statute is an aspect of the state's motion. I'm going to leave it to Brad Miller, counsel for Kelly and Michael Ward, to address those additional requirements that the state has urged the court to adopt. Our reply at pages 5 to 8 also covers that material. Trying to make sure I don't repeat what's already been covered, but all right, so next I'd like just to talk about how we have met our prima facie standard in our motions. We have met our prima facie burden. Unless the court makes a prima facie showing right now, I'm not going to reply to the extensive counter arguments in the response. I think that would be, again, out of order. So I'm going to use what's in our motion and what's in the indictment which I think is properly where our motion should come from at this point. There are only two elements to what the defendants must show. One, that they engaged in protective activity that was lawful, and two, that the defendant retaliated against them for that activity. As the court knows, the anti-SLAPP statute protects the rights of petition, speech, freedom of the press, association, and assembly under the U.S. and Arizona constitutions, and the Arizona Constitution is broader in its protection. As counsel for Professor Eastman has discussed, the indictment is based on the defendant's exercise of their First Amendment rights. We also address this at 15 to 17 pages 15 to 17 of our motion. I will note that it may be helpful to think of there being two sets of constitutionally protected activities that are discussed in the indictment. First, here's the activities such as serving as an elector, including signing the elector certificates. That is specifically what the indictment seeks to punish as a crime. As has been explained, that is a constitutionally protected activity. Second, however, there's also activity in the indictment, such as expressing criticism of the administration of the election, joining lawsuits, or in Mr. Hoffman's case, writing a letter to the vice president or giving a news interview, that are also protected and which apparently earned their place in the indictment, but are not in and of themselves alleged to be the criminal act. The assertion which, I thought we heard this afternoon, not so long ago, that filing a lawsuit and putting a theory before a court might be a criminal act, I think is shocking and unsupported by the law. I don't think that even warrants much more discussion. A prosecution that retaliates against or deters either set of protected activity, that is something that is the alleged crime, like signing the certificates, or the other material that's in the indictment. I think both sets of activity by their place in the indictment trigger the anti-SLAPP statute. And this gets to the word involve, which we were just talking about earlier. The indictment involves protected First Amendment activity beyond the actual act of signing the certificates that is the basis of the charges. And therefore, the anti-SLAPP statute can apply for either of those sets of activity. So I'd like to spend most of my time actually remaining addressing why the exercise of these rights was lawful and specifically did not constitute the crimes alleged in the indictment. While I can only speak to for Senator Hoffman, a lot of what I'm saying will apply to the other electors and a lot of the other defendants as well. So count one, and this is where I'll spend almost all of my time, count one is conspiracy. In count one, the indictment, as we explain on page 34 of our motion, the Arizona Supreme Court has held that conspiracy requires that the defendant intend to promote or aid the commission of a specific crime and that he agree with another person that the offense be committed. So we need intent and we need agreement. Indictment does not show how Senator Hoffman or any elector or defendant intended to promote or aid in the commission of a crime and to that end agreed with others to commit that crime. If we look at page 13 of the indictment, there's a bare conclusory assertion that defendants, without identifying any one of them, had schemed. There's no statement as to who, what, where, when, or how they schemed. On page 13, the indictment vaguely asserts that unnamed defendants falsely claimed election fraud to pressure officials without identifying which one made the statements, what statements were made, why they were false and not just opinions, that they indeed believed their own statements were false, or any evidence the defendant's statements were part of an agreement to act in concert to commit a crime. To put a fine point on it, there's a difference between a group of people committing fraud and a group of people expressing an unpopular political belief, whether they're right or not in what they believe. Page 13 again makes a vague and conclusory allegation that defendants deceived Arizonans by claiming their votes were contingent. However, the indictment concedes the defendants were claiming their votes were contingent and not the actual elector votes, which introduces a glaring inconsistency in the central theory of the indictment. So is the theory that the electors were culpable for saying that their votes were contingent? Or is the theory that the electors were culpable for not saying that their votes were contingent? The indictment tries to have it both ways. There are no allegations showing that the electors knew or believed that they were saying anything inaccurate, much less that they intended to deceive or defraud other people when they asked various officials for help.